So if you're saying that effectively this case where this local ban on guns like the AR-15 or AK-47 and magazines that hold, I believe it's 10 rounds in this case, the standards change depending on what state and law you look at with large, so-called large capacity magazines. But the lower courts here have upheld the legality of this law, the constitutionality of it. The Seventh Circuit has declined to issue a stay against that ruling. They've declined to block the law effectively while the case continues on the merits. And so you think that Amy Coney Barrett, seeing this development in the lower courts, now at least wants more information to get a better understanding of why the lower courts and the government in this case you think they can ban these kinds of guns and magazines, and potentially that the full court is going to look at this on an emergency basis. What are the possible outcomes? Could they actually, do you think it's likely that they'll issue this injunction that the plaintiffs want, that they'll block this law?
Well,
at this stage,
this becomes complicated for the following. It's always generally complicated trying to figure out what the Supreme Court's going to do, but it's extra complicated here because of that other parallel case I mentioned, Stephen, that came out of the Southern District of Illinois. Judge Stephen McGlynn entered an order enjoining the state of Illinois' so-called assault weapon ban and magazine ban about a week ago. So there's
a dichotomy there between in this state over whether these sorts of bans are legal.
Yes, exactly. And this is going to make a big difference to the Supreme Court. And let me just explain to you why. Initially, when the emergency application was taken to Justice Amy Coney Barrett by the National Association for Gun Rights and Mr. Bevis, at that moment in time, or at least right after that moment in time, Judge McGlynn entered the injunction that prevented the assault weapon ban and the magazine ban from going into effect in Illinois. Now, if that had continued, I could see the United States Supreme Court looking at the situation and saying, look, we don't need to get involved with the Illinois situation because the potentially unconstitutional law has been enjoined by Judge McGlynn in the Southern District of Illinois. So the Supreme Court doesn't need to do anything because the law has not gone into effect. That would have increased the odds, I think, of the Supreme Court doing nothing because they'd feel like we don't need to do anything because the law is not taking effect. We'll just deal with it down the road after the cases progress in the normal process. But what's changed things is that just yesterday, Stephen, as you know, the Judge McGlynn injunction of the Illinois bans was stayed, which means put on pause, by the Seventh Circuit Court of Appeals, specifically by one judge named Judge Frank Easterbrook, who was the author, by the way, of the McDonald versus Chicago case that ultimately was reversed by the United States Supreme Court in the McDonald versus Chicago case that said the Second Amendment protects Americans against state and local gun control laws. So Frank Easterbrook, Judge Easterbrook, is not viewed, at least in the elite legal circles that I travel in, as favorable to the Second Amendment for many reasons. But nevertheless, the point is that now you have the excuse that Amy Coney Barrett could have used to not get involved with the Illinois law was, we don't need to because Judge McGlynn has enjoined the law. But now that the Seventh Circuit Court of Appeals has stayed that injunction, which has the effect of these laws kind of going back into effect, now they can be enforced. Now, at least I believe, I'm not sure where the state stuff is, but at least I believe in the federal system, those laws are now back into effect. I'm not sure if there's any state injunctions that are still out there, but set that issue aside for the moment. That means now you may have an unconstitutional law that has gone back into effect, has become alive again. That now increases the odds, I think, of the United States Supreme Court and Justice Amy Coney Barrett feeling the need to step in, because now you have these allegedly unconstitutional laws have arguably gone back into effect because of the Seventh Circuit. Now, to make things even more complicated, Judge Easterbrook has demanded or has said that the plaintiffs, the Second Amendment plaintiffs in that case in front of the Seventh Circuit called Barnett, Judge Easterbrook says he wants any briefing submitted early next week. So it's quite possible in the next 7 days, Judge Easterbrook in the Seventh Circuit could get rid of his stay, which means if he got rid of his stay after looking at all the papers, that means the Judge McGlynn injunction would come back into effect and the ban of the guns and the magazines would again be turned off and not be enforceable, which again would flip the odds of the Supreme Court acting from they might to they don't need to anymore. So the conduct of what Judge Easterbrook's going to do in the next week or so in the Seventh Circuit Court of Appeal is going to increase or decrease the odds of the United States Supreme Court acting involving these Illinois gun ban laws. And I know it's a little complicated, but that's why you have to look at both cases simultaneously because they dictate what may happen. And of course, the flip side is that if in the Seventh Circuit Court of Appeals, Judge Easterbrook continues to stay and enters another order, having looked at all the papers, and basically says, I'm going to continue my stay of Judge McGlynn's order that enjoined the laws. If he were to do that, that would actually increase the odds potentially of the Supreme Court acting, especially if the plaintiffs' lawyers that support the Second Amendment were to seek an immediate emergency appeal to the United States Supreme Court. From that now you'd have two sets of cases, both of which arising out of Illinois, with all the major Second Amendment lawyers involved, including Paul Clement's firm, who argued Heller and argued McDonald and argued Bruin. Now you have his law firm, I believe, is the lead law firm. So you got all the parties in front of the Supreme Court on what should be an extremely easy legal question, which is these bans on so-called semi-automatic rifles and magazines are easy cases at the end of the day. They cannot be banned because they're in common use by millions of Americans for lawful purposes. And there's no dispute about that basic fact, which means they're protected. And the Supreme Court, I think, will take notice of that. So again, it's a long-winded way of saying it's complicated, but at the end of the day, it does break down with some straightforwardness.
Wow. So these assault weapons ban cases, or this issue over assault weapons bans, might rocket to the front of the line, I guess, when it comes to Second Amendment decisions that the court has to make, it sounds like.
Yeah. And again, one of the things I've always said, look, I never want to see a bad outcome that hurts the Second Amendment. I never, ever think a loss, whether it be legislatively or regulatory wise or constitutionally, I never think any kind of infringement on the right to bear arms is a good idea. So with that said, there is sometimes the case that bad news becomes good news because as we've talked about before, Stephen, stupid gun control laws, like we saw in D.C. with the handgun ban, gave rise to Heller. The Chicago handgun ban that was silly out of Chicago gave rise to McDonald. The stun gun ban, which was dumb in Massachusetts, gave rise to Catano. And the May issue permitting regime where New York says, basically, you can't have a gun unless you come to me and say, Mother, may I have a gun to carry outside the home and show that you're special in some unique way. Those kinds of silly laws sometimes give rise to really powerful Second Amendment precedents by the Supreme Court. So this attack on the Second Amendment after Bruin, especially these so-called assault weapon bans, are relatively easy cases. And I could see a situation where, the anti-gunners have again bitten off more they can chew and try to virtue signal to the point where they're going to give this layup to the U.S. Supreme Court to simply enter a short order, basically saying that you can't ban commonly owned firearms. We said that in 2008 in Heller. Nothing has changed. It's still the law of the land. Please follow it, lower courts. I could see that happening in this situation, especially if Judge Easterbrook were to continue his stay and prevent the very well-written decision by Judge McGlynn essentially enjoining the assault weapon ban in Illinois. If that doesn't come back to life, I could see the Supreme Court actually taking a step and doing something really unusual and stepping in and enjoining this law, which would be unusual, but I could see it happening here.